Welcome, everyone. We would like to remind you that flash photography and video or audio recording are prohibited in the theater. Please take this moment now to silence your cell phones. Thank you.
Hello, good evening, and welcome to our annual presentation, Law of the Land, the Supreme Court Cases Year in Review, co-presented with FOLKS, the Forum on Law, Culture, and Society. I'm Susan Engel, and I have the distinct pleasure and privilege to be the executive producer of the Recanati Kaplan Talks here at 92nd Street Y. This event is always an eagerly anticipated one, and this year even more so, as we look back on the extraordinary changes and cases the Supreme Court has dealt with, especially those most recently, and we are also looking with an eye to the future and what's next. Our format is a moderated discussion followed by your questions. As a community center committed to fostering an active citizenry, we encourage your questions and participation in tonight's dialogue. For those of you in person, please hand your cards to the ushers as they walk down the aisles. And for our live stream audience tuning in from all across the country, please enter these in the chat. And now I'm delighted to once again introduce our moderator and longtime good friend, Thane Rosenbaum. Thane Rosenbaum is a novelist, essayist, and distinguished university professor at Touro University, where he directs the Forum on Life, Culture, and Society. He is the author of various books of fiction and nonfiction. His essays and reviews have appeared in major news outlets, and he is a frequent guest on various news programs. He is a columnist for the Jewish Journal and serves as the national legal analyst for CBS News Radio. He has moderated programs on this stage for more than 20 years. Please welcome our good friend, Thane Rosenbaum.
Thank you. Thank you, Susan. Yes, this is home for many years. Folks, for the last 2 years and 3 months, we've done 55 virtual events. This is our first live event where the guests are sitting on the same stage. I've really missed this. And look, you can feel and touch it, and you're out here. I think 4 times the number of people that are in this room are watching virtually. We've done events over the last few years where people from Turkey were writing questions. And we also have a global audience today, so welcome all of you. And so I'm not shortchanging you wherever you all are, but I'm saying it's good to be live on this stage, and especially this stage that I've been on for so many years. And I'm going to share with you an anecdote about an earlier Folks event that involved Justice Breyer soon. Yes, Law of the Land is one of our more popular events. This has been a tumultuous year. Obviously, in the Supreme Court, we had a leaked opinion in a case that ultimately overruled Roe v. Wade. We've had an assassination attempt against, can you believe I'm saying this? There's an assassination attempt against a sitting justice on the Supreme Court. There have been protests against justices that continued all throughout even this past weekend, and the first female African-American justice has been appointed to the Supreme Court. And I haven't mentioned really any of the cases yet. That's just what happened. So there's a lot to cover, and we have a very special group of people. Everyone on the stage has been on Law of the Land before. They're really the all-star team you're going to see. As you know, a Folks event is super smart and entertaining, and we mean to please. So we turn really complicated things into something that everyone understands, and experience in the sort of in a conversational format. First over there, my good friend Mark, she's from Slate, Mark Stern, who's senior writer at Slate and is also the Supreme Court correspondent. My good friend Mark Stern. I just want to say, Mark Slate is not a bad name. It's cool. It's like a spy. Over here is Tiffany Graham. She's my colleague at Touro University. She's a superstar constitutional law scholar at Touro University Law Center. Tiffany Graham. I'm going to skip over here and talk about my good friend Ariane DeVogue. You see her face all the time on CNN, where she is the Supreme Court correspondent and does such an amazing job. She also writes for CNN.com, and what she's really also very unique in this world of coverage of the law. She's interested in the personal lives of the justices. And that's rare. People, you know, they're opaque to so many of us. They become less opaque during the pandemic, which is sort of interesting. But she tracks them. She knows them. If there are tensions between them or among them, she knows. So we're going to talk a little about that. Ariane DeVogue. And I'm saving Bill Traynor for last. Longtime friend. Bill Traynor is the dean at Georgetown Law School. He's being mentioned last because I'm often credited with being the founder of Folks. It's true and it's not true. He actually is the founder of Folks. He was once the dean at Fordham Law School. He came to me one day when I was teaching there. He said, you know what, we're not using you right. This is a great anecdote. He said, we're not using you right. You're a novelist, you write culture pieces for the New York Times. You know, we can use your Rolodex in a better way. And you know what, we're right across the street from Lincoln Center, and ready for this line? He says, light this place up. He says, light this place up. Now, let me tell you something. In the history of law schools, no dean has ever said, light this place up. It's just not what they say. It's an enormously unique thing. And we lit this place up. and he's now at Georgetown, and he's lit that place up. They have way more programs than any other law school because he has a very lively mind and an entrepreneurial spirit, and he lights things up. Before we start, one last thing, a little Folks anecdote. When we first started out, it was the salad days before we had guests like Bill Clinton and Sonia Sotomayor and Susan Sarandon and Kristen Stewart and Paul Giamatti. Yes, they've been on our stage. Elie Wiesel. In the beginning, it was salad days, and I was trying to light this place up, and I was looking in this audience, and there were these two little redheaded kids that were sitting in the front row, little ones. Their feet didn't touch the ground, and they were his kids. And they were sitting there every event. That was how I was lighting up for them. And they were eating popcorn, they had red hair, and they're here today, which is freaky to me. They're adults, so Liam and Catherine Traynor are here. They go way back.
And I just want to say, Thane, I never imagined what you'd be able to do. I knew it would be great, but it is beyond great.
Well, thank you, Bill.
Round of applause for Thane.
Thank you. All right. We're going to start off with a few questions unrelated to the cases and then get into the cases, and trust me, we're getting everything out. I'm going to start with Ariane on this one. The internal investigation on this leak of the Dobbs opinion, that is the first draft in February that was leaked in May. There's 50 people that could have done it? How do they not know? Do they know and they want to tell us because it's embarrassing? How come no one's reporting what's happening? The court's not even in session anymore. The public wants to know. Do they know?
Well, let me tell you, first of all, to understand how stunning the leak is, you have to understand how different the Supreme Court is from the other branches of government. This is a very insular building. There's a newsletter that comes out. They have a Christmas party. Clarence Thomas knows the names of all the employees. There's a woman who runs the elevators. This is a very insular community. So when this leak happened, all of you might have been like, well, leaks happen. It's Washington. Not in the Supreme Court. We've never had anything like this. And just to show you the extent of it, Clarence Thomas, soon afterwards, I was in Atlanta, and then he gave another talk. He compared it to an infidelity. That's a really interesting word. He was so stunned by it, and he said it's making us all look over our shoulders. to get to your answer, we don't know much about the investigation. We've had little bits and pieces. And one of the reasons is because they don't do anything openly. They do it all behind closed doors. We know that the marshal has been interviewing some of the clerks. And we know that there are lots of procedures. For instance, the clerks who work there, there's burn bags where they're supposed to put draft opinions when they're done with it. But the reporting I've done shows that there's a possibility that some drafts went home with people because there just wasn't a sense that anybody would ever do this. They just never thought they would. So back to your question, we don't know where the investigation is. They've been a little busy. They needed those clerks to help them finish this term, but we do know that there's investigation going on, and we'll just have to see what it comes down to.
Mark, is there any reporting that you've done or anyone's done? Because what we've had, the bits and pieces that Ariane is talking about, there's intimations that, I mean, we know everyone loves to tell the story about how Scalia and Ginsburg would go to the opera together. They didn't agree on anything judicially and constitutionally, but they agreed on opera and they liked to have dinners together. But we also believe that maybe a lot of the justices actually don't like each other and don't want to go to dinner together, and don't. And so there's been some intimations that there's some tension among them from this. They're pissed off at each other. Is that true?
So the analogy that I have heard is that the Supreme Court right now is a bit like a war zone, and that everyone is incredibly skeptical of everyone else's trustworthiness, and that the affection and the love that they all claim to have felt for each other for so long is out the window. And they now think that they're all double agents, and they're all conspiring behind the scenes to take each other down. And one thing that I found fascinating about the talk that Ariane just mentioned is that Justice Thomas praised to the hilt the Supreme Court that lasted from 1994 to 2005, from when Breyer was put on the court to when Rehnquist died. And Thomas lost so much during that period. He was frequently losing. He was in the wilderness. He was this...
Meaning he was always in the minority position.
He was in the fringe vote.
Dissenting position.
Not just dissenting, but frequently dissenting by himself, with nobody else, even Scalia, willing to join him. And yet now he says, that was a fabulous court. I love
when nobody liked
that
me.
court. And now he says, but I hate this court. In so many words, I don't feel like I trust this court. As Ariane said, it's an infidelity. And remember, he left his first wife for Ginny, so he knows infidelity. And I think it really shows in these public comments the anger boiling over that was almost always concealed from the public until now. And so what is surprising is not just that it exists and that they don't trust each other, but that they are going out there and telling us that this is getting very dirty behind the scenes. And again, just an unprecedented peek behind the curtain for us, and it suggests that all is not well at SCOTUS today.
Tiffany, the public protests. You're a con law professor. You have a sense that this is an austere institution, opaque, cerebral. They're not political by nature. The opinion itself in Dobbs says, we don't want to be in the abortion business. Let's put it in the political sphere. It's a moral, political issue. You handle it. And now there are people publicly protesting outside houses, and there are death threats. Obviously, this has never happened before. I'm wondering whether maybe you and Bill could describe one idea, which is, do you think there's a First Amendment right here that should be exercised? Do you think this is appropriate? I'll tell you what happened to me over the weekend. CBS called me. You might know this, Ariane and Mark. CBS called me on Saturday. There were letters written from the marshal's office to the governors of Virginia and Maryland. And this is what the letter said. They said, forget federal laws about intimidating justices because they're not ruling on any decisions anymore. But aren't there property rights in your state that says that if you're an owner of a home, you have the right to peace and tranquility? We're asking you to protect these justices and arrest these people because they're disturbing the peace of the property owners who happen to be Supreme Court justices. My understanding is both governors didn't want to do it. They thought it was too political for them to deprive people their voice in the public sphere. Do you have any thoughts about this?
I think that's a really interesting question because, on the one hand, you're talking about people who are legitimately receiving death threats in certain instances. On the other hand, you are talking about a tradition of being able to protest public figures, being able to protest them if you're standing on a sidewalk. That is traditionally something that is deeply protected, the right to do that. And so when you see the effort to constrain people who don't cross into your yard, but stay on the sidewalk, stay away from your property, don't in fact issue death threats, and you are a public figure, trying to constrain that seems very contrary to what we understand of First Amendment doctrine, what we understand of First Amendment norms, of free speech norms. And so I don't know. I mean, I don't know what rules are going to end up emerging, but I will say that I am very skeptical of the efforts to shield them from the appropriately, calibrated rage of the public, as long as no one is trying to threaten anyone or go on to the private property, et cetera. Them's the breaks. You're a public figure. This is something you have to deal with. And if you decide to overturn a right that people have, in fact, despite what the opinion said, relied on for half a century, you can expect that there's going to be some blowback.
Bill, I was wondering, you've been, I didn't mention this before, but I love telling this story. You're like the Cal Ripken of deans. I think you're the longest serving dean in the United States, consecutive dean.
Could be.
No, no, you are. I checked. And the reason I'm asking you this question is because I'm wondering, Chief Justice Roberts, and you know this because you cover this, is very upset about the politicization of the court. The court is very aware of the plummeting polling numbers, that they've never really polled this low. What is it, 25% of the country has public confidence in the Supreme Court? I think that was the most recent polling. That's just awful, and it's the lowest. You've been an educator in law schools forever. Do you feel like Roberts? You have your own, you worked in the White House as a lawyer, you clerked for a federal judge on the Second Circuit. Is this hard for you to watch as the dean of a law school, to see the Supreme Court maligned so publicly, treated with such disrespect, death threats?
I mean, it's very hard to watch, but at the same time, it's also very hard to see a lot of these decisions. So Roberts is very much an institutionalist. We saw that in Dobbs, and we'll talk about Dobbs. We saw it in Obamacare. And I think one of the things that he's grappling with is, that you have 5 very conservative justices of the court, who are just in decision after decision, making big decisions that are kind of at odds with where the American public is. And in a lot of cases also breaking with precedent. So, I think that's underlying, what we're seeing in terms of, the dramatic drop in terms of the view of the court.
And that explains it. Tiffany, last question before we get to the cases. You are an African-American female. The appointment of Justice Jackson to the Supreme Court, personal to you, obviously. Can you share any of those feelings with us?
Well, sure. I mean, as a black woman who's part of a constituency that regularly turns up to vote, this is incredibly important to me, seeing her rise. I mean, watching her name show up over the years as someone who was, on track.
Well, that's important for us to know. Not everyone knows that.
Yes.
So for people who are Supreme Court watchers, she is not unknown.
Not at all.
People know, so it's not like, well, if they ever found someone, we would appoint them. They found someone, they just didn't appoint them.
And she's related by marriage to Paul Ryan. That was part of the reason that we began to figure out who she was. But I will say, so watching that process, connecting with her, I'm a Harvard undergrad, and I came to Harvard about a year or two after she left. So these connections between her and me, they feel very real. I mean, I didn't expect to cry when she was sworn in, but I did. But beyond that, this year was not my reunion year at Harvard, but because of the pandemic, a number of years came back, and I declined to go. I'm busy. But I will say I am so angry with myself for not going, because when I look at my friends who did go and all their photos on Facebook, she was there. And they're in pictures
And they got
with her,
photos with her.
and they've got pictures with her forever. My coolest famous political person photo is with Chelsea Clinton. Ketanji Brown Jackson would have totally lapped that, but I did not go. But yes, it's very
All right,
personal.
one last a little anecdote, and then we'll get to Dobbs. About where, I guess if we move the chairs closer, we had Justice Breyer, who just retired. Justice Jackson is filling that seat. We had Justice Breyer for Folks, I think 8 or 9 years ago. You're going to love this. We have among our very series, some of you might have even been here, we have a series where we see classic movies, the audience watches a classic movie, and then we have a special guest. So we had, say for instance, we had Justice Sotomayor, the audience watch 12 Angry Men, and then we talk to her about it. And so we were here at the 92nd Street Y. There was Breyer. I was over here, and we came out. And the movie they had just watched was the John Ford classic with John Wayne and James Stewart, The Man Who Shot Liberty Valance, right? A classic Western. And this is a liberal justice. And he and I are talking, and if you know anything about the film, and this is important because of the Second Amendment case that we're going to talk about today, this was a gun movie. It was a cowboy Western. And the point of the film is that James Stewart is a lawyer going off to the territory of California before it becomes a state with his law books to open a practice. And John Wayne is already a cattle rancher with a gun. And every time James Stewart tries to impose order, the bad guys push him down and knock the books out of his hand. They don't care about the law books. And he's going, I'm a lawyer, and nobody cares. And John Wayne, everyone cares because he has a gun. So Breyer says, and this was like amazing, the audience, if you were here, was stunned. He says, you know, sometimes you just talk too much, and sometimes you just have to bring a gun. I know, a liberal justice said this. And then he said, and you'll love this, he then said, people talk about Brown versus Board of Education and the Civil Rights Act and the Voting Rights Act and all the cases that went before the Supreme Court incrementally changed, gave us the civil rights movement. But when it came to integrating schools in Mississippi and high schools in Arkansas, you needed the National Guard. You needed to bring a gun. And that was an interesting moment. And I just want people to reflect on that, right? Because one of the things that he's saying in discussing The Man Who Shot Liberty Valance, that guns are part of our history. And oddly enough, that is something that Tapas talked about, right? And I think I'm going to ask Bill about this when we get to the case. But it is interesting to think about that Breyer was acknowledging the violent history and what sometimes is necessary to bring order, right? To a lawless, and I don't know if we should do this now unless you have something you want to say right now about that that might help.
You know, I mean, so we have a violent history.
Yeah.
Right? But, you know, this kind of calls to mind Louis Oberdorfer, who was one of Bobby Kennedy's top aides. I heard him talk about, you know, the integration of University of Mississippi,
Yeah.
right? And the violence that the National Guard was responding to, that, you know, that they were kind of lined up in front of the buildings, and that there were people who were driving down to, you know, to run over the National Guardsmen, right? And what they relied on was their force, right? But I think the question is, you know, we look to government to protect us. You know,
Not
we
to
don't look-
individuals.
Not to individuals, right? And that's what I think Breyer was saying.
Okay.
And we'll talk about
Good.
that in Bruin.
I love that. That's a good way to, and it's a good anecdote because it's a Western and because this was a lawless country for so long. And you're right. The big distinction there is he said bringing out the National Guard, not arming every individual with a firearm. All right, let's start with Dobbs. Tiffany, let's start with you. You know, there are conservatives and Republicans who say, what's the big deal? The law doesn't, this case doesn't ban outlaw abortion. It just simply says it's a political and a moral matter that should be handled by the states through state legislatures and let them decide. As a con law professor, how bad a decision is this?
Well, there are con law professors who would disagree with me. I think it's terrible. And the reason I think it's terrible, I mean, there are a variety of reasons, but one of the most important reasons that I think it's terrible is because when you think about women's equality, one of the most important things that is crucial for women to be equal in this country is for us to be able to control our reproductive capacity. And in a huge number of states in this country, it is going to be very, very difficult now for women to do that. There's this concept called abortion deserts, where if you live in a city and you are 100 miles away from a clinic at minimum, you are in an abortion desert. There are so many abortion deserts that are going to arise as a result of this decision. They are going to arise in the South, the Southwest, in the Plains, parts of the West. And when you think about not just the women across the board who are going to be impacted negatively, women who don't have the means to travel to a state where it is, abortion rules are more flexible, but when you think about marginalized women, women of color, white women who are poor, this is going to devastate their lives. And so when I think about it from the standpoint of equality, I think that this is a terrible decision.
So Roberts comes in with his own concurrence. And one of the things he says, and I remember this from law school and as a law professor, I thought the Supreme Court makes decisions incrementally, right? They go slow. And Roberts seems to be saying that, right? He seems to be going, why this sweeping overturning of Roe v. Wade? Why not just say, which was the original legal question before the court, right, that all pre-viability prohibitions on abortion, are they unconstitutional? Was Mississippi, was it unconstitutional for them to say, forget the trimester of 23, 24 weeks of viability, let's just move the bar, move the goalpost to 15 weeks. And that's essentially what Roberts is saying. Decide the case there. Just say, drop the case, say it's not true that all pre-viability are unconstitutional, and we are prepared to not invalidate this Mississippi law. Explain to us, any one of you, and maybe we can move around a little about this, what was the fire?
Can I just jump in briefly?
Yes.
I mean, this case was litigated in an extremely unseemly and unscrupulous way. What Mississippi did was tee up a 15-week abortion ban as a test case to get the Supreme Court to move back the line from 24 weeks to 15. And in its petition to the Supreme Court saying, take this case, they said, all we want you to do is move it back to 15 weeks so that we can experiment with protecting unborn life. They had all this hooey about fetal pain that is pseudoscientific and whatever, but they wanted this to be the incremental step. The Supreme Court takes up the case, and Mississippi comes back and says, oh, never mind, ignore all that. Now we want you to overrule Roe v. Wade altogether. And
Can you explain this? Maybe Bill and Tiffany can also go. They can do that? No, I'm saying they could say, we briefed the case this way, but what the hell? Let's just overturn. It's like a bait and switch. You're describing a bait and switch, right? Let's just move the bar from 24 to 15. Nah, never mind. Let's just overrule. They can do that procedurally?
You sound like John Roberts.
Yeah, that's why I want to talk about Roberts, because Roberts seems to be saying, and I thought one of the justices, you'll all know, I won't, one of the justices said to the Attorney General of Mississippi, what are you doing? Right. Didn't you argue a different case? What are you doing here in front of us? Didn't something like that happen?
Yes, absolutely. But only John Roberts cared about upholding these basic rules of appellate procedure, which sound boring, but are pretty vital to a functioning and stable rule of law. The other 5 justices on the right were eager to reward Mississippi's underhanded tactic because they were in just as much of a rush as Mississippi Republicans to chuck Roe out the window when they had the opportunity.
Marianne?
Well, the oral arguments were super interesting that day because we walked in there trying to figure out where people were, and immediately Roberts forecasted what he wanted to do. You could see the sign flashing over his head, middle ground, and you could see on that bench nobody was picking up on that middle ground. He was trying to trying to be incremental to say, let's just stop with the Mississippi law and we can do Roe down the line if we want to. And nobody picked up on it. And you could see the sensitivity to what's called in scary legal circles stare decisis. That's the whole idea with the law, that you don't eagerly overturn precedent because that causes instability. So what Alito did in that opinion was write 2 pages of footnotes, which you rarely see, detailing all the times in the past that cases have been overturned.
As
So-
if I'm not inventing something.
yeah, look, this is here. And Kavanaugh did the same thing. And then what he does in the opinion is lay out sort of a 5-factor test for when you can overturn precedent. So going in there, you kind of knew Mississippi was going to do that. I remember when the day their brief was due, I was sitting by my computer because the chances are that they were going to at least try this were very high. And Roberts was left behind.
So, Bill, I want to just ask you this question. I'm going right to you. I'm a Georgetown law student. I'm really upset about this decision. I see you in the hallway. Dean Traynor, what is the meaning of precedent now? What is the meaning?
What we've seen in actually all of these decisions is a disregard for precedent, right? So, one of the things that they cite, the majority cites is, what about Plessy versus Ferguson and Brown, right?
Now, those are the case, right? Just to
So Plessy versus Ferguson says separate but equal segregation is okay. Brown versus Board of Education says not in public schools, right? So, but, if you go back, the NAACP Legal Defense Fund came up with a legal strategy that was about a 10-year strategy in which they said, we're going to chip away at Plessy. So we're going to say Plessy doesn't apply in professional schools. Plessy doesn't apply in colleges, right? And then they lay the groundwork. So it's the kind of thing Roberts would have wanted to see.
as an institution.
Right, that he wanted to see. So then finally, and this is what, so none of them, even the dissent doesn't get this, that Brown was the product, one, of a whole series of cases. It wasn't a one-off.
Over a 10-year period.
Over a 10-year period. And two, if you go back and look at Brown, it does not overrule Plessy. It says Plessy doesn't apply in public schools, right? It was another 3 years before they overturned Plessy. So even the dissent doesn't get how long this took before Plessy versus Ferguson was overturned.
So, by the way, Bill, is the answer to this question, I hope it's right, that's Thurgood Marshall as a lawyer?
He's one
So that's important, just historically speaking, what Bill was describing, a 10-year run-up. And my understanding also is that Ruth Bader Ginsburg picked up on that strategy.
Exactly.
Right? It's like, this is not new, this strategy of, let me show you how we get to that big case. It takes a long time, but you do it incrementally. And, by the way, it might explain why now everyone seems to be saying, well, Ruth Bader Ginsburg thinks that Roe v. Wade was wrongly decided. And when they say that, are they saying it because they thought that they didn't, like that she was essentially saying that Roe went too far, that it didn't follow that more incrementalist approach?
Right. So I think there are two things. So, one thing, as you're thinking about kind of moving forward, right, one of the questions is what you do in the courts and what you do politically. Right, so Evan Wolfson, who is really the architect of the marriage movement, is here today.
Our buddy,
He's
Evan.
Evan, and so that led to Obergefell, but the whole strategy was there. You build a political movement, right? Mm-hmm. And I think one of the things that Ginsburg said, 40 years ago was Roe was too quick.
Yeah.
You should have built the political movement first.
I see. And that's what she was talking about.
I think
But
that's
in fairness, if I could say really quickly, I don't agree, obviously, with the Dobbs decision, but I don't want to discount what anti-choice activists did in the courts and did in the legislatures. I mean, you have Gonzalez versus Carhart, which came down in the early 2000s, which did real damage to the viability line in that particular opinion. And then, of course, you have state legislatures passing these trap laws, targeted regulation of abortion procedures, where they chipped away and chipped away and chipped away.
But Tiffany, isn't that what we were told was going to happen? For years we were told, don't worry, Roe was safe. All that was going to happen is more chipping away.
That is what we were told, but to the degree that we're talking about incremental movements, we may not have seen a lot of incrementalism at the level of the Supreme Court, but we certainly saw it in the state legislatures.
You're saying the other thing that Bill is talking about. You're saying the reverse. The other side played the long game.
They did.
The other side did the incremental approach, and they succeeded, and they did it without us noticing, or not noticing it enough.
Or not recognizing, or to some degree, I mean, we did notice, but what we didn't count on was Ruth Bader Ginsburg dying and the court going conservative 6-3.
But one other thing, while we're talking about planting seeds in this opinion, we can't forget about what Clarence Thomas said in this opinion.
Yeah, I'm going to get to that next. It's perfect timing. Go ahead. Go ahead.
You want to get to it?
I just want to know, what is
see if it's the
substantive
same
due
point.
process?
Well,
What is substantive due process? What does the penumbras, can we still read a privacy right into the Constitution, or is that over?
So what Justice Alito said is, look, this case is about abortion. And even though there are other cases, gay marriage cases and others that have some
Same-sex intimacy, same-sex marriage, contraception.
that may have some of the same reasoning. Alito said, and he says it twice, this case is just about abortion. And he
As
differentiates.
if to say, relax.
And he says, because abortion is about taking potential life. Well, Clarence Thomas writes a concurrence, and he says, okay, this case is just about abortion. But he says, I think that we should take another look at Obergefell. I think we should take another look at these cases. And so then you get this fascinating dissent that is written by 3 liberals, and we don't know who, but boy, oh boy, I think Justice Kagan wrote a lot of it. And she says, majority, isn't it fascinating that Justice Thomas isn't on the program here? And she says that exactly. He's not on your program. He is saying that this is not a one-ticket opinion. So maybe right now on this court, there's others, Alito, who said we're not going there, but Clarence Thomas, as he always does, has planted the seed here in Dobbs.
Okay, go ahead.
I just want to say how grateful I am to Justice Thomas for writing that opinion, and telling the truth, because Justice Alito tries to gaslight us over and over again. His reasoning makes no sense. The thrust of his opinion is that if there is an unenumerated rights found in the Constitution, something like the right to marriage, the right to abortion, contraception, whatever, that it has to have been rooted in tradition and history in 1868 when the 14th Amendment was ratified. And if it wasn't widely accepted in 1868 when the 14th Amendment was ratified, the Supreme Court has no business protecting it. Oh, but also this opinion only has to do with abortion and nothing else. It's not going to touch anything else. And Alito has this quintessentially whiny bit because he's always so aggrieved. He's always the victim. And he says, oh, people are going to say this is about more than abortion, but don't listen to them. Listen to me, the most trustworthy man in the world, Sam Alito. It's only about abortion. And then Thomas comes in and says, don't listen to that. It's garbage. Clearly, this affects all of these other rights. And by the way, I am on a mission to overturn those other rights as quickly as possible. And I am glad that he laid it all out so that when others try to gaslight us about the consequences of this decision, we can cite Justice Thomas himself and say, you are lying.
All right.
And
Go ahead.
just very quickly, I would say to that point, one, I agree with you. I am also glad that he said that. I will say I am not convinced right now that there are 4 votes to grant cert to overturn those decisions.
I agree.
Having said that, he has given an open invitation to activists who file test cases to do that very thing. And so if you are gay in a state like Texas, if you are gay in a state like Utah, what have you, then you are sitting at home right now and you are wondering which of my rights is going to potentially be litigated tomorrow. Even in Florida right now, in the wake of the passage of the Don't Say Gay bill, you have teachers who have been told if you have a photograph of your wedding photo with your same-sex spouse, take it down. What kind of world does that feel like? So I think that the fact that he has opened the door to this is really dangerous, really disheartening.
Right, and I mean, to go back to Mark's point, the whole Alito opinion is essentially the substantive due process doesn't make sense. right? Because, you know, it's only enumerated rights, substantive due process is not enumerated.
You
So
got
the
to
whole
tell
line
them
of-
substantive due process. You got to tell them.
So basically, the 14th Amendment says everybody's entitled to due process. So the Supreme Court has read all of the Bill of Rights into that due process clause. But there are also rights that are not listed in the Constitution, like a right to privacy. And the court, in a series of cases, has read, you know, gay marriage, has read interracial marriage, has read, you know, anti-sodomy laws, as unenumerated rights that to take away violates due process. So we call that substantive due process.
But conservative Republicans and conservative justices on the Supreme Court will say, unenumerated and invented. You made that up.
Right, and so one thing that I don't get is, you know, again, he's like, it's only enumerated rights. Well, the Ninth Amendment says there are rights that are not enumerated, but they still exist, right? That's an amendment to the Constitution. You know, why is that?
Okay.
You know, for an originalist, why does that not matter?
Right. Okay, let me just get one last question. We got to move on. One last Dobbs question. Is this over? Because I'm wondering, does this case answer teenage pregnancies, fetal abnormalities, morning after pills? Is there a way to go back with, given what's the, you know, the literally the morning after? None of that stuff is resolved? Are we just simply supposed to assume now it's the states are going to make that decision?
This is all a mess. It's the Wild West right now. You're looking at state Supreme Courts that are issuing injunctions, or I guess state trial courts issuing injunctions on trigger laws for various reasons. You have people who, for instance, have diseases that are not pregnancy related at all, but they can't get access to their drugs because the drugs can be used as an abortifacient.
But
So
could it
it's
get
a
us back
mess.
to the Supreme Court? That's what I'm wondering. They're saying it's not our business. And I'm saying, well, there's all this, it's a wild, wild west. You just heard Tiffany Graham.
But can I just
Yeah, yeah.
jump in? They actually don't say it's not our business, right? Kavanaugh says it's not our business, right? So, I mean, when you're thinking, so one of the things that people have thought about is, you know, what are the long-term implications? So substantive due process, which is right to marriage, you know.
Same-sex
same-sex-
intimacy, same-sex marriage.
Right, you know, interracial marriage, contraception, they're saying that's all in play, right? But you also have 4 votes on the court, I think, that would say you become a person at conception, right? So what that means is not that the Supreme Court stays out of abortion law. I think you have four votes in the court that would say New York can't allow abortion.
That's really interesting. I'm not sure. I mean, I agree with you from the standpoint of thinking about them from a moral perspective, what their morality is. But when you look at the index of laws from the 19th century that Alito included after the majority opinion, in each of those laws from the 1800s, there was an exception for the life of the mother in these laws that criminalized abortion in some way or another. And given their reliance on history and tradition, I think it's
wow.
possible. I
Wow.
think it's possible that they might, A, rely on that, or B, maybe think it's a due process violation to say if she's literally dying, then you actually can at that point intervene for her. But that also brings back, you know, this question of how people are interpreting Dobbs. You have hospital lawyers right now who are saying, in effect, she has to be dying before you can intervene and terminate the pregnancy.
Right, so 2 points on that. You know, one is, you know, if I had to predict where the court goes, I think eventually they would say life of the mother, you know, states have to recognize that would violate due process to not recognize that. But I also think, you know, Kavanaugh goes to great length to say, this is not our business. We're not in the abortion business. So New York can take one stance and Mississippi can take another, right? I think what he's signaling there is that there will be a case in which people are saying the right to life starts at conception and a state can't take that away. You know, that any abortion legislation, you know, is going to be struck down, right? And I think he's saying, I'm not in for that.
Okay. All right, my board chair for Folks, Jeff Lenoble, is here, and he said there was no way we could do tonight and not do more than Dobbs. And so I want to say, Jeff, we're rolling, buddy. We are past Dobbs. Okay, let's do Bruen case. This is the New York, this is personal to us, the New York Second Amendment case. New York had a law. Well, first of all, let's just remember the Heller case in the Supreme Court over 10 years ago said, the Second Amendment is not just about a well-regulated militia. There is a right of private ownership of weapons inside your home if you're a law-abiding, normal person and you have reasons to use it for self-defense in your house. Over 10 years have gone by. Conservative justices like Thomas and Alito are going, how come we're not talking about more gun cases? What do you mean? What happens outside the house? What happens outside the house? Well, they finally got one. That's the New York case. Over 100 years, New York's law was, you can have a gun inside your house, but you can't ever take it outside your house unless you get special permission. You have to have a proper cause, which I'm assuming that means if you're having an affair with some guy's wife and he threatens you and I'm going to kill you, you know, you can literally say, I think he's going to kill me. And so I need to be able to carry my weapon outside and I need permission. And basically, Alito is saying that's not true of any other constitutional right, where you have to ask, and when you're speaking, you don't ask the government, can I have permission to speak? Because this is what Alito is saying, right? Thomas. Thomas is saying, and Thomas wrote a majority opinion. So he's basically saying, and unless I'm reading this wrong, he's saying, New York has a stupid law. That doesn't mean you can't regulate guns. You just can't regulate it that way. I'm not closing off the possibility of assault rifle bans or mental health checks or any number of other regulatory schemes. But this law just doesn't make sense, and it's not consistent with how the other Bill of Rights are read. Tell us, I mean, Bill, well, you could start, but maybe Mark, you can start.
I completely disagree with your take on that case. I do not think that's what Thomas says. I think what Thomas says is that the Second Amendment protects the right to self-defense. Words that do not appear in the Constitution, by the way, but that didn't stop them from saying that there is a fundamental right to self-defense, and that any law that imposes restrictions on the right to self-defense is presumptively unconstitutional, and that the only way that the government, whether it's the state or the federal government, can save a law that restricts the right to self-defense is if it can pinpoint a historical analog, so some kind of similar or identical regulation that existed either in 1791 when the Second Amendment was ratified or in 1868 when it was applied to the states. He's very ambiguous on which is which. And then he goes through, and I want to be clear, Clarence Thomas is not a historian, and if he tried to be a historian, he would fail out of the program immediately. He does this amateur hour, dilettantish, pseudo-historical analysis where he cherry picks these regulations throughout history, and he just cuts out the ones that don't adhere to his narrative. And he says, well, I don't find a sufficient number of laws from 1791 or 1868 that regulate the carrying of weapons outside of the house.
Well, I just want to say, did anyone watch Bonanza today? I'm not kidding. I was rowing it. I have a rowing machine at home. Picture that for a second. Okay, I have a rowing machine, and I watch mostly cable news, but I'm flipping through, and Channel 33 has old Westerns on it. And I'm just saying, today's episode, I kid you not, if you were watching, the sheriff has a rule. I don't know, this is 1875 or something. The sheriff's rule was, you got to leave your guns in town. You got to give me the gun. You can't be near the saloon. And I'm wondering, isn't that what Thomas is talking about? Or is that something Thomas should have said, that there were laws where you couldn't walk around with a concealed weapon? The sheriff imposed his will in the Wild Wild West and said, I want your gun because I don't want you near a saloon with a gun.
If you tried to carry a weapon into a town in the Wild Wild West in the exact period that Clarence Thomas is talking about, you would have been arrested. The pop culture myth of guns everywhere in the American West is absolute garbage. And so many real historians, not fake ones, have pored over the historical record and shown that there is not a tradition in this country of public carry, whether it's concealed carry or open carry, that there is a robust tradition of restricting the right to self-defense, if it actually exists, to the home, and that public carry was strictly limited and in fact outlawed in states like Texas, which we are today considered to be the vanguard of the Second Amendment. And that, in fact, what Thomas does is he identifies these jurisdictions that I'm discussing now, and he says, well, those are outlier jurisdictions. But they aren't. He's just lying. And this brings us to another theme that I hope we can touch on, where this court, this majority, is very comfortable completely manipulating and bending the facts of the record in the case, of the historical record.
Oh, I know where you want to go on that.
To fit its narrative.
I'm coming
and
back
reach
to you
its
on that.
constitutional
I know where you want
ends.
to go.
And that bothers me a great deal, because if we're going to chuck out all con law and replace it with this history and tradition stuff, let's do real history and not pretend like the Wild West of 90s TV shows is the real deal.
I'm coming back to you because I know exactly what you want. Bill, do you want to add to this? Bill actually is a legal historian. So do you have, I mean...
I actually have a PhD in history.
He has a PhD in history, and on his tax returns, I think it says legal historian.
It does,
Yes.
yes.
It should say that. All right. So
Yeah, I mean, you know,
do you agree with Mark on this?
I mean, I think it's even more serious than Mark is saying. You know, so there are two readings of the Second Amendment. Does the Second Amendment protect an individual right to have a gun, or does it protect a militia's right to essentially protect the state against the federal government? You know, and there are some people in 1791 who say it's an individual right, but overwhelmingly, it's a militia right. So it's not your...
So Heller's wrong.
So Heller's wrong, and if Heller's wrong, Brune is totally wrong. You know, so, you know, I mean, what Mark is talking about is kind of the tradition of regulating guns, but it's more fundamental than that. You know, Brune is based on a decision that's bad history. And I think if the court is going to have originalists who are going to say we look to history, they've got to do it seriously.
Okay.
See, I see the case from a different prism, because I think what he says is, I'm dealing
Thomas.
with this New York law, and there are a handful of other laws that need to fall in 6 different states, and then he goes through this long historical analysis. But while he does it, he does something that most average people kind of didn't pick up on right away, is that he changes the standard going forward as to how judges should look at every other law. So at the case at hand, we're talking about New York's law and the 6 other laws, but going forward, when this begins to hit in the lower courts are going to look at all sorts of other kind of laws through this different standard. And that, to me, was the headline in this opinion. And why I think that that is important is because the dissent begins with gun violence. Breyer's writing it. He begins with mass shooting, and he really lays it out where we are, something that Thomas doesn't do. And then you get Justice Alito writing a concurring opinion that was, to me, so odd, because he, in about 8 pages, writes this opinion to criticize Breyer and the liberals for talking about mass shootings. And he actually says, why are we talking about mass shootings when this is only about New York's law and a handful of other laws? But he never mentions in that concurrence that the standard has been changed. That was very odd to me. And talk about tension in the court. And maybe I'm missing it, but I don't understand how he can criticize them without talking about the changes.
Tiffany?
I think that's really important. You know, I was going to say something about that myself, because what the court did here on this point about the standard, normally when you are evaluating fundamental rights, like the rights in the Bill of Rights, what the court would typically do is implement this test where they looked at how important was the government's interest and how precisely was the regulation that was how precisely drawn was the regulation that was trying to achieve that interest. And that was the normal way that they would evaluate that. Thomas chucks that for the Second Amendment and says, no, we're not going to do that anymore. We're going to talk about history. And so when you talk about history, you take gun violence off the table, because if you talk about gun violence, then you're talking about the importance of the government's interest. And quite frankly, what that also does is it, in some sense, elevates the importance of the Second Amendment above the other rights that we evaluate in the Bill of Rights, because they are still using the standard for the most part, where you're looking at the importance of the government's interest and the precision of the regulation targeted to achieve that interest, versus just saying, can we find it in history? Can we find the regulation in history or find an analog? That's going to be a harder thing to do, as opposed to looking at whether or not the government's policy makes some degree of sense.
Right. I mean, one of the things that he says, which is just wrong, is that they're just bright lines except with the Second Amendment. And that's just, I just
Congress
don't...
shall make no law.
Yeah, I mean, everything has a balancing test, as Tiffany's saying, right? And so what he's saying in the Second Amendment is no balancing test. You can have mass shootings, that's irrelevant. And, now...
Meaning that the offsetting state interest.
The state interest is irrelevant.
Yeah.
It's just, you have an individual right to do this. It's
It's
irrelevant.
paramount, right.
It's not, it's all that we focus
Right.
on.
And I think that's especially stark coming the day before Dobbs, which the court frames as a paean to state sovereignty and says the people and their lawmakers are supreme. We must defer to the sovereign states.
Except when it comes to guns.
Except when it comes to guns, state lawmakers cannot pass any regulation unless they can prove that with a seance with James Madison that he would have wanted it to exist. And judges, when evaluating those laws, are literally prohibited from looking at the empirical effects of a law. If there is a law that a state passes that cuts mass shootings by 100%, judges literally cannot consider that fact in evaluating its constitutionality. So much for state sovereignty and self-government.
So let me just say something. Mark Stern, he's loaded for bear. No, seriously, I'm afraid to bring up the next case because I wanted you to talk about it, because this one, he's loaded for bear. Are you ready for this? We're going to talk about your football coach case. I knew where you're going. So let's talk about, and I know that Ariane wanted to talk about this too. So let's just talk about these two religious liberty cases. They're very super important, enormously interesting. The first comes out of Maine. Just to remember, the Establishment Clause in the First Amendment. The First Amendment says you have a right to practice your religion, free exercise of religion, but the government isn't in the religion business. It can't establish a religion. It can't endorse a religion. It can't pick sides in religion. It can't use federal funds to support a religion in any way. Hence the separation of church and state. And usually when it came to public entities, they understood this. They were fearful of violating the Establishment Clause by using, in a public school, by using any funds toward something that could seem as if the state, through a public school, is endorsing religion. So here we go. Two interesting cases. One is in Maine, where if you live in a rural area and you have no high school, but there are public high school, but there are private schools, including private sectarian religious schools, the state will subsidize the tuition for you to send your kid, because I'm sorry, we just don't have a high school, right? And so the question there is, but you can't give federal funds to people to give it to St. Matthew's, especially if St. Matthew's ever mentions Jesus Christ, right? So that case is before the Supreme Court, and the Supreme Court essentially says, no, you can't. You can give them money. You can't discriminate. This is what we're calling the religious liberty cases. You can't discriminate against religion. And in this case, you'd be discriminating against religion because you're favoring all the other schools, and there's no equal protection for the religious schools. And then here's the one that I know where Mark is going. The one, and you've all heard about this on the news. This is the football coach in Washington State who, according to the opinion, right, the story is, at the end of the game, not during halftime, not during the school day, but when the game is over and everyone's going to get Dairy Queen, he ran out to the 50-yard line, took a knee, and silently prayed. Just so happens, some of his players went out there too, especially, I guess, if you're a third-string defensive tackle and you want to start next week, it might not be a bad idea, right? Go out and follow even if you're Jewish, why not? What the hell? So go, They go. And in fact, I'm told that even opposing players would some join, sometimes opposing coaches, a member of the press. They have like a little thing going at the 50-yard line. So eventually, I think what happened is something mentioned to the principal. The principal got scared. Oh, damn, we're violating the establishment clause. And they fired him. And the Supreme...
No, they suspended him.
Oh, they suspended him, and he's been in Florida.
Paid leave.
Paid leave. He's been in Florida as a semi-retired football coach. And now the Supreme Court said...
Because he sued.
He sued them, and the Supreme Court said, well, yeah, the establishment clause, but he still has religious rights. He has the rights to practice religion, and he's not forcing anybody.
And silent private prayer.
He's engaged in private prayer. So these are what we would all call religious liberty cases. We've seen the court doing this more and more. There's yet another one that I'm going to ask Tiffany about next. Mark, why don't you start with this?
I mean, I want to just start with the lies that are ubiquitous in Justice Gorsuch's opinion, because you said silent private prayer, right? This is the line that this poor, sweet football coach, Joe Kennedy, was persecuted on the basis of his Christianity for engaging in silent private prayer at the 50-yard line. Go to Justice Sotomayor's dissent and look at the photograph of that silent private prayer. He is standing in the middle of a massive prayer circle, holding up his helmet so that everyone can see him, with TV cameras all around, because he brought them there by posting on Facebook that he had been fired, which was not true. And he led overtly Christian prayers with his teammates, which, according to Justice Gorsuch, was not at all coercive, even though some of the teammates attested that they felt obligated to join, even though they were not Christian, because if they didn't, they feared they would not get playing time on the field. And Justice Gorsuch's opinion simply bulldozes over these objective facts, proven with photographic evidence, and says that he was only penalized for quiet private prayer, and tells the students who were offended by this, who felt coerced, he says, well, these kids just need to learn that living in a pluralistic society such as ours requires us to be exposed to speech that we dislike. And I would like to print that out and mail it to the justices who are upset about the protesters in front of their homes. Because if it's good enough for the Jews and Muslims who are being coerced into Christian prayer, then it's good enough for Amy Barrett and Brett Kavanaugh, who are tired of having to deal with people criticizing them on a public road.
Wow. Ariane? Well said, Mark. I knew you had that.
So I'm going to step back just a little bit, because I think that this is one of these cases that was very interesting.
Which one?
The Kennedy's, the coach.
The coach, okay.
Because I think that the lawyering here on behalf of Kennedy was superb.
Kennedy's the name of the coach, just
Yeah.
to be clear.
So Paul Clement, one of the best lawyers in the country, he looked at this case, and in a certain way you were looking at two different cases, because the coach had started quietly and his prayers had escalated, and then the school found out about it, and then there was a back and forth. But what Paul Clement did is he looked at why the coach was suspended, and the coach was suspended in the letter from the school district for 3 different prayers. So the liberals were looking at the entire set of circumstances, and Sotomayor fills the opinion with that. But the conservatives were able to say what the school district did here was these 3 prayers, and were able to sort of focus very tightly on that, and focus on the fact that the school itself, in suspending him, never talked about coercion, even though Sotomayor shows that there's coercion. So it really is interesting how it comes to the court. And when you read that opinion, you're reading 2 entirely different cases, 2 totally different set of facts. They're talking past each other, and I thought that was fascinating.
And I will add to that, that very point that you just made says something really interesting about which lawyering choices the court will ignore and which lawyering choices the court will nail you with. In Kennedy, they nailed the school district with bad lawyering on the school district attorney's part with respect to the letter that was written. But in Dobbs, they did not do the same thing with respect to the lawyers who filed their cert petition saying we don't want to overturn Roe and Casey, and then later came back and said, oh, by the way, actually we do. So this is yet another example of the hypocrisy that we are seeing from this particular conservative majority on the court with respect to the choices that they make about which lawyering errors they're going to gloss over and which lawyering errors they're going to rely on when they reach the decision that they want to reach.
So
I think
Bill,
that's-
okay, I want to
yeah.
ask you something. Go ahead. Would you
No, I
have
mean,
to
I
add
think
to-
that's very interesting in terms of when the lawyering matters and when it doesn't matter. One point that is just striking, just an interesting factoid, at least for me, of the 6, it's about public high schools and football, and of the 6 conservative justices, only 1 went to a public high school.
Oh, wow.
So they don't really understand high
Right.
school and public football.
Well, I was going to ask you something about this.
Go ahead.
Perfect timing. Excellent. So I hope you won't, you're a good Catholic boy. Grew up in New Jersey. Dad's a doctor. What if you didn't grow up in Morristown, New Jersey? You grew up in a rural part of Maine. And all the trainer kids are really smart. And you're working on a farm. And you don't have a high school. Why is it that in this instance, would you make an argument? Can you see the argument in the Maine case that said, we don't have a public high school. We can't discriminate. If the trainers want to send their boys, they just happen to be Catholics, they want to send it to St. Matthew's, they would go to a public high school. They like the trainers. They're not like the justices on the Supreme Court. The trainers would support a public high school, but we don't offer that. So why can't we let the trainer boys go to a Catholic school?
Well, the trainer boys can go to a Catholic school. They'd have to just pay for it, right? It's not.
But they can't afford. Say they can't afford.
So, so I think one thing that for me is just very striking in these decisions, and that we're seeing in the court right now, is the Establishment Clause disappears.
Yep.
Right. I mean, and it's really striking in all of these decisions. It's essentially, there's been an infringement on religious freedom, and we're done. There's no sense. It actually goes back to the balancing point. The way in which we've traditionally looked at rights is, there's a balance. There are competing interests, right? So on one hand, so in this case,
the main case.
The main case, right? So it's just, well, this is an infringement on religious liberty because, Maine will send this kid to X private school but not to Y Catholic school, right? So you're discriminating against this kid who wants to go to the Catholic school, right? But, what the dissent says is, look at what they're teaching in the Catholic school. They're teaching Catholicism. And actually, these are not Catholic schools, but, they're teaching religion, and the state is supporting religious training.
Clearly an infringement on Establishment Clause.
And so that's an Establishment Clause violation. And that's just not in the opinions. And that's
That they're acknowledging that we're overriding the Establishment Clause.
Right. So in other words, I think one of the things that's said in the majority opinion is the Establishment Clause and the Free Exercise Clause harmonize. They're in the same amendment to the Constitution. No, that's not the way it works. It's never worked
They're
that way.
opposites.
They are two values that are at tension, and the Supreme Court has always said we've got to have the balance, right? The other point that I just want to make, and again, it's a through line on all the cases we're looking at, is a conservative court that is disregarding precedent, right? So Heller overturned precedent. Dobbs overturned precedent. Kennedy overturns Lemon, right?
Right.
And these courts...
The Lemon test.
The Lemon test. The Lemon test is essentially a balancing test in freedom of religion versus establishment, right? And the conservatives on the court say that they're originalists, but the originalists believed, the original Supreme Court believed in stare decisis. So what does that mean? The Marshall Court, which was 40 years, how many constitutional decisions of theirs did they overturn? 0. That's what the original understanding. When the Supreme Court makes a decision, it sticks with it. But that's not what we're seeing. We're seeing in big case after big case, precedent is just gutted.
So let me, okay, can I just add one thing to this? Because I want to talk about something that Tiffany and Bill said earlier. Remember, they explained how you sort of build the case over a long period of time. So just to give you some law of the land context, I don't remember what year it was, but it was 3-4 years ago. We were on this stage right here. It wasn't the same group. It was another group, but they were not as good as this group or as good looking. I'll tell you that right now. And I remember this case. I don't. You guys will remember the name. People will remember the name of the case. But it was the case of where state funds were set aside to put rubber on playgrounds, right? To throughout all the state to say, look, it's really dangerous. The jungle gym, you fall off that, you die. And so I grew up like that, and I survived. But nowadays, you know, the helicopter parenting, you need rubber everywhere, and so the state set aside the money, and the Supreme Court, it went to the Supreme Court and said, well, what about the Catholic schools? What about the yeshivas? What about, you know, Islamist schools? Why should those kids crack their heads open? Can't you just give them? And I'm wondering, is that an example of like something that we didn't see coming?
Oh, gosh. Yeah, let me talk about that.
Yeah.
So here's what's
Go ahead.
fascinating about that one. So that happens, and now I know that Kagan was in the majority. And
In that case.
And Breyer, I think, too, but don't hold me to it. But the key to that was that we're just talking about funds going to playgrounds. We are not talking about it going to instruction. And I think there was a footnote to say that, and the liberals joined in on that. And at the time, I remember some saying, what the heck are those liberals doing? Because they are joining in on this opinion when they know very well that the next step is going to be this. And my question now is whether or not Kagan, and I mean, it doesn't really apply more to Breyer, who were willing in the early days to find narrow places of agreement and did it, whether they'll do it, whether she will do it going forward, because they saw what happened. It's the Roberts 1-2 punch, and this is where it is. And I just don't think that she'd be willing again to say, okay, if you're just talking about playgrounds, let's just talk about playgrounds.
All right. I want to make one quick comment. I want to move on to the administrative law case, the regulatory cases, to make sure we have those. Can I do that? Okay. So let's move to the regulatory cases, because if you worked at the Environmental Protection Agency or the CDC or OSHA this year, this was a terrible year for you. It was a terrible year because in each of those cases, and I know you want to talk about this, in each of those cases, the court said, well, you're agencies, but you're unelected and your money comes from Congress, and you don't have the broad authorization in the EPA case to say that the EPA gets to establish national standards for greenhouse gas emissions, carbon emissions. Congress has to do that. In the case with the moratorium on evictions for COVID, the CDC said you can't kick people out even if they're not paying their rent because it's going to spread COVID. And the landlords are saying, we're totally kicking people out, right? And the CDC doesn't have the authority to tell a private a landlord in Greenpoint who to throw out and who not to throw out. And then remember there was the case from OSHA where OSHA said, if you have 100 employees and you're a private employer, you have to make sure that you have all your employees either vaccinated or they're tested or they have to wear a mask if you have 100 people. Otherwise, we can't contain the spread of COVID. And the Supreme Court said, you can't do that. You don't have the right, you don't have the authority to do that. So those are three very strong cases from this conservative court that said that there is a big check on regulatory authority and that it really should be Congress's call, not agencies.
Right. Well, the conservative project has been to cut back on the authority of agencies. And you saw that Donald Trump's White House counsel, Don McGahn, this was something that meant a lot to him. And Gorsuch and Kavanaugh were put on the bench because of their beliefs. The conservatives believe, and Gorsuch writes about this very eloquently in his book, he believes that an agency is unaccountable to the public. It can't have that kind of power. It violates the separation of powers. Where the liberals, on the other hand, say, look, these agencies have the expertise. They need the independence. They should be able to step forward and protect workers' rights, protect climate, et cetera. And we have really seen that come to a head now, and it came to the head in this EPA case, which was about the EPA's authority to regulate
Power plants.
existing power plants, the emissions from existing power plants. And basically the Obama administration had a very broad view of the EPA's ability here. That got struck by the Supreme Court, wouldn't let that. Then Trump came in and he said, no, the EPA doesn't have such broad authority to do something nationwide. They can maybe make improvements to certain power plants, but they don't have the ability to do it nationwide. So the big question with this case was how the court was going to resolve it. Most people thought that the court was going to say that the EPA didn't have the authority, but would they issue an opinion that would be much more than just an opinion about the EPA's power? And in fact, that's what they did. John Roberts brought up this legal doctrine, and I hate saying legalese things, but it's called the major questions doctrine. And the reason that's important is he was saying that his belief was that if an agency wants to do something very, very broad, having to do with a major question, it has to have the specific authority of Congress. And that's why this term, he brings that up. He curbs the EPA's authority and sends a chilling signal to agencies across the board that they now are going to have a lot less.
I mean, this is a huge case. This is a huge case because
Wait, of the three I mentioned, the EPA.
Yeah.
EPA
in
case,
particular,
right? Because what we're seeing is the conservative wing of the court, which is 6, because Roberts is on board with this, right, wants to really do away with the administrative state, right? And is very pro-business. So this is interpreting a broad statute that basically says the EPA gets to regulate, in this area, and it's very broad. And what Roberts says is, and he creates this doctrine, he says, this is a major question. And if it's a major question, you've got to do it with greater specificity.
And Congress has
And
to.
Congress.
And Congress has to do it, right?
this,
But
not
these
you.
guys are textualists, right? What they say is, what does the text say? And what in this opinion, it's really like, well, you can't just read what the text says because it's a major question, so we're going to require more. And it's part of this entire tact on federal regulatory agencies. It's a huge deal.
And Elena Kagan is amazing here because Elena Kagan said several years ago in a speech, she was praising Scalia because Scalia really turned the way judges look at the law, and he was a textualist. And he said, really, you've got to look at the text when you're interpreting it. And she said, that we're all textualists now. And that was her concession that he had really opened people's eyes to a certain kind of way of looking at the text. In this case, she is so boiling mad. She says, a few years ago, I said that we're all textualists now. Well, turns out we're not, because when you have something that you don't like and you can hang it on this major questions doctrine and then throw away any sort of look at the text, she really called them out on it, and it just shows her anger and her tension.
So how do we explain? Let me just quickly comment, and then I want to do one question, and we'll get to questions from the audience. But
I just want to say, what I find outrageous about these opinions like EPA is that the Supreme Court's conservatives, they clearly hate these federal agencies, which are, by the way, what make government run. Federal statutes don't interpret themselves. We need the EPA, the Department of Labor, the CFPB, whatever, to be interpreting and enforcing these statutes. And what the conservative justices say is, well, we don't want these beady-eyed bureaucrats in the bowels of government making these huge decisions about what the law means. These bureaucrats, they are undemocratic, they aren't elected, they're unaccountable, and their solution to that ostensible problem is to transfer this immense power from these bureaucrats to themselves, who are unelected, who have no constituency, who are completely unaccountable, who are worse than agencies because agencies answer to an elected president, and these judges, as they remind us a lot these days, answer to nobody.
And they have lifetime appointments.
And they have lifetime appointments. So while the conservatives call decisions like this a coup for democracy, it looks a lot more to me like just a plain old coup.
All right, now, having said that, right, last question, last case. We'll take some questions from the audience. Last case. How is that consistent with what happened in the Remain in Mexico case? Because in the Remain in Mexico case, remember, that's based on, I guess it starts with the Department of Homeland Security that says if you're trying to seek asylum from Central America in the United States, this is during the Trump era, you can't come into America and wait for your hearing date. You have to remain in Mexico. And we got to convince the Mexicans to keep you there because we don't want you running around here. Either you show up for your date, you don't show up for your date. So Biden's administration wants to scrap the policy, right? And the Supreme Court, you would think, right? You would think that the conservatives on this court, 3 of whom were appointed by Trump, would do everything to preserve the Remain in Mexico policy. And instead, they affirm the right of the Biden administration to scrap it. And the reason I'm asking this is because a year ago, when we talked about this, Tiffany and Bill might have been there was the DACA case, right? It's very similar, right? It started with an executive order. This was the Dreamers Act. Trump tried to scrap the Dreamers Act, and this conservative court turned around and said, well, you can't because you don't have a good reason, right? You got to give us a better reason. You don't have a good reason. So is the difference here that there was a good reason to scrap this? Remember, what the Biden administration said is it's really dangerous to make people go to Mexico and wait there. And secondly, it's really diplomatically very difficult for us to convince the Mexicans to keep them there. And that's our reason for scrapping it. How do we explain 3 Trump justices preserving the Remain in Mexico? Oh, right, 2, right. Is there a way to explain?
I mean, I think, some of the Trump justices, are supportive of presidential power, right? And, this was a clear case involving presidential power. So what happens is, under the statute, 3 things can happen. It says, when somebody's in this country and they may be here illegally, you can detain them, you can parole them, or you may be able to keep them in the country they came from, Mexico, right? And so the presidential power argument is, it's a may, it's discretionary. And if you require that the president enter into an agreement with Mexico, you're telling the president what he has to do. And maybe Mexico doesn't even want to do that. So if you have any concern for presidential power,
I see.
This is an easy case. It should have been, I actually think it should have been unanimous.
And it was complicated by the fact that the district court judge in that case issued the broadest decision, basically saying that if you don't have beds for people here, if you're not able to detain them, well, then you have to have such a program on the books. And that was such a broad decision that you knew that they weren't, not even.
Right, and that was just clearly unlawful. It was just clearly unlawful.
But it is an indication of where the lower courts are these days. And that decision, that was out there.
Yeah.
That district
So
court.
basically the statute says lower court judges can't enjoin the federal government in a case like this, and he enjoined the federal government. So it was not complicated.
Questions from the audience, and this includes questions from virtual audience. What's the probability of expanding the court?
Low. It's an interesting question. It's an ongoing conversation. I will say that if by some miracle the Democrats held the House and expanded their majority in the Senate, theoretically, if such a bill ended up on President Biden's desk, I just don't believe he would decline to sign it. But as far as reality goes and seriously hoping for something like that to occur, I think the odds are very, very low.
And Breyer and Ginsburg both didn't think that was a good idea.
Here's something that's similar. Can the term limits help solve the problem of the politicized court? This person says, example, Germany. In Germany, it's 18 years, or if you reach the age of 68, whichever comes first. Legal historian Bill, when did the idea become lifetime appointment? Was it always lifetime appointment?
Yeah, I mean, so actually the Constitution has lifetime appointment, fixed tenure, and you can't be kicked off. And that's new. Actually, none of the state constitutions have that. It's kind of a much stronger protection for the judges than we'd ever had. I mean, I think if you had term limits and you made it retroactive, applied it to the current justices, I think that they would strike that down. I think moving forward, it's something that you could have, but it's a very long, if it's an 18-year tenure and it's the new justices who come in, it's going to be very long. I mean, the problem that we're seeing is, first of all, that, we have so many justices who are put on the court by presidents who lost the popular vote. That's part of the issue. But, it's also just the happenstance. Carter got no appointments in 4 years, Trump got 3. And then also the happenstance of how long people live, is also just something that has incredible consequence. If Ruth Bader Ginsburg had lived 6 more months, we would be having a very different conversation.
Here's a loaded one, but I'm not going to hold back. Ready? How is it possible that Clarence Thomas has not been sanctioned or made to recuse himself when cases come before the court that he has a personal philosophical interest in voting on or in a particular way? Now, let me just say, if you've been here with us for an hour and a half and paid attention, we've dumped all over Thomas. So it seems like we're going to end on this, too.
I'll take the liberty of expanding the question to how can he do this when his wife is implicated in the attempted coup and was actively coordinating with state legislators and the president's chief of staff to try to overturn the election? How is it that Thomas can still vote in these cases and, in fact, be the lone justice to vote to prevent the January 6th committee from obtaining documents that might implicate his wife? And the answer is that we have created a Supreme Court with no mechanism of accountability. Let me repeat that. No mechanism of accountability. There is no ethical code that applies to the Supreme Court. There is no realistic way to get a justice off the bench. I guarantee you no justice will ever be impeached and removed in the history of the Republic, period. And every single other country thinks that the way we do this is totally insane, and every single other country is dead right, because we are creating a system that facilitates not only corruption on the bench, but deep disregard and distrust and disgust of the Supreme Court that is supposed to be the great guarantor of liberty and of the rule of law. And so, we could spend time dumping on Thomas for violating every known ethical rule in the book, even though they don't apply to him. But to me, the deeper problem is that he is seriously tarnishing the reputation and legitimacy of his court. And for those of us, myself included, who believe that the court's legitimacy should take a serious hit, Clarence Thomas is doing more work than I could have ever hoped for in that realm.
Tiffany, I want to end with you because I want to talk about Justice Jackson. Given what Mark said with all that passion, Justice Jackson is really young. Let's hope that she is really healthy. Let's just, take care of her, send her vegetables and things, because she could theoretically think about how long she could be on this court. When you hear Mark, do you at least think, yeah, but she's really young. She's going to have a huge impact over decades, hopefully. And that helps moderate some of the concerns that Mark is talking about.
I don't think that. And the reason I don't think that is because of what I am observing with respect to state legislatures and the way that they are passing laws that make it very likely that Republicans are going to continue to be elected to Congress. And that is not a knock on Republicans. It's an observation about the conservative movement today and its desire to maintain power really at almost any cost. I want to be careful when I say that. I don't want to suggest that there is no respect for rules on the right. I'm just saying, watching what's happening and watching some of the laws that are being put in place that would, for instance, allow state legislatures to theoretically overturn the popular vote during an election, that worries me. And when I see that, what I see is it will likely be very difficult for Democrats to capture the White House, increasingly difficult because of these structural barriers that are being put in place throughout the country. And that also relates to the number of Democratic senators that are likely to be elected in the future, which in turn impacts who is going to sit on the court. And as long as we continue to have a right-wing majority that is ideologically aligned with at least 5 and possibly all 6 of the conservatives who are currently on the court, then I do not think that, I definitely don't see a future where her voice is going to really, truly matter. Maybe it will. I hope it will, but it's not something that I am anticipating at this point.
Wow, and actually that's an amazing answer, and for me a surprising answer. It's painful to hear, but it's something to really reflect upon. What a breezy night. Wow. No, really breezy, smart, entertaining. That was awesome. You guys are great. Mark, I want to thank you, and Tiffany, and Bill, and Ariane. We will have you back here again, of course, for Law of the Land in the future. All of you, thanks so much for showing up, actually, and keep coming back to the 92nd Street Y. Sign up at folks.org. We love seeing a live audience, even in masks. And by the way, we can't see anything. It's totally dark out there. Good night, everyone. Drive safely. Thank you all.